Welcome to Canada's most irreverent talk show. This is the Andrew Lawton Show, brought to you by True North.
Canada's most irreverent talk show here on True North on this Wednesday, January 24th, 2023. The Freedom Convoy 2 years ago today was just passing through Alberta, I believe, picking up steam on its way to Ottawa. So that's something to keep in mind there. We have, I believe, I'm just looking at our little show production chat channel thing, whatever we call it here. And one of my colleagues has a new profile picture. Send that over to Sean, Artem. I want to put that up on the screen for people. I kind of like that. So I'm very easily distracted, but you'll understand why in a few moments when we put this up on the screen. But you may have heard yesterday, if you've been sleeping and in a coma for the last day and a half, perhaps you haven't. But yesterday we had the big ruling from the federal court, and specifically Justice Richard Mosley finding that the invocation of the Emergencies Act was unjustified. It was not keeping with the parameters and the legal tests set out in the Emergencies Act itself. And more crucially, the measures that the federal government brought into effect under the Emergencies Act, like the freezing of bank accounts, the conscription of tow truck drivers, this whole suite of things, violated the Constitution. It was unconstitutional. It violated a couple of provisions of the Charter of Rights and Freedom. So we are going to chat about that in a little bit more depth today, now that myself and other guests here have had the chance to go through the 190-page ruling. I was very grateful yesterday that Christine Van Geyn from the Canadian Constitution Foundation had just sped read for half an hour before coming on air, and made far more sense than most Canadian politicians ever would. But we have her on now with the benefit of having been able to take a deeper dive into this. Christine Van Geyn, it is good to talk to you here. Thank you so much for coming back on. So now that you've had the chance to look through this, I'm curious what your takeaway is, because obviously you agree with the outcome, as do I, but the reasoning behind it, do you find it's sound, and is it based on what you would have hoped as a lawyer it was going to be based on?
Yeah, so these are very detailed reasons where Justice Mosley goes through not just some of the preliminary matters like standing and mootness, but really dives into the crux of invocation. So he spends a lot of time dealing with whether or not the threshold to invoke the Emergencies Act was met. And then he looks at, once finding that it was not met, then he goes through the measures enacted under the Emergencies Act. That was the freezing of bank accounts and the prohibition on gatherings, and found that those were unconstitutional. So we can talk about any of those. He also gave a shout out to counsel. He said that one of my favorite quotes was at the end of the decision, and he said that the advocacy was wonderful. And he said in kind of radical transparency, he said, when this case started, I was leaning the other way. But for the advocacy of groups like the Canadian Constitution Foundation and the Canadian Civil Liberties Association, this case could have very well turned out differently. So to receive that type of sort of shout out from the bench it's a wonderful, wonderful feeling.
I wanted to ask about that, actually, because I've not read as many of these things as you have. I've read probably more than is healthy for a normal person, but I've not really come across a judge being that transparent about their own evolution on a case like this, whereas he was basically saying, look, at the beginning, I was leaning this way. Is that as rare as it seems on the surface?
It is. So judges will sometimes, if counsel is particularly good or particularly bad, either give a nice or a mean shout out to the lawyer and say that this counsel was exceptional or this counsel was bad. You don't want to be on the bad end, because then
there was one of those in this case too. I saw it was one of the groups, Canada Frontline Nurses, just got a rather scathing rebuke by the judge.
Yeah, I was there in the courtroom, so I saw what the lead up to this was, and frankly, it was pretty well deserved. I wasn't surprised that there was some criticism from the bench of that one particular lawyer, because his argument started with a discussion about the Prime Minister wearing blackface, which of course he did, but it's not really.
But there's not really a legal argument in that. It's more of a just by the way.
Yeah. Anyway, yeah, it is rare to receive kudos like that from the bench. So we were very thrilled to get that.
I wanted to ask you, because one of the things you and I spoke about when your book came out, Pandemic Panic, not that long ago, was that freedom of assembly is a very underdeveloped area of law. And I was curious what your take was on if that's a bit more developed now, or if that really weighed in this decision in a meaningful way.
So Justice Mosley wrote that there was no breach of the right to freedom of assembly because he said the right to freedom of assembly comes with a caveat, which is freedom of peaceful assembly. So he was not concerned with the gathering limits breaching that right because he said the gathering limits prohibited participating in a gathering that that could reasonably lead to a breach of the peace. So he said those gatherings are protected anyway. I mean, I do quibble with this because I don't want to say too much because it may be a ground for appeal. It may be involved in the appeal, but I understand the position that he took because it does have that caveat in the right, but I don't agree with the conclusion that that right was not violated. But the important thing to know about the right to freedom of assembly is that it is an underdeveloped right in our charter. There's not very much jurisprudence on the right to freedom of assembly. And we wrote in our book that the pandemic presented a number of opportunities to develop a legal test of what constitutes an assembly. Now, in this case, there clearly was an assembly. The question on whether or not something is an assembly more is geared to whether, private gatherings like a Thanksgiving dinner would constitute an assembly under the charter. I think that it would, given that the text of the charter doesn't delineate what the purpose of the gathering needs to be. But anyway, that's sort of not what this case was about. He found there was no breach of the right to freedom of assembly. The breaches were the right to freedom of expression, because a protest is an expressive event. And he found there was a breach to privacy rights, that the disclosure of information from bank accounts was an unreasonable search and seizure that was unjustified.
I wanted to ask about something that follows up on a discussion we started yesterday, which was the distinction between this and the Public Order Emergency Commission. And just to bring people up to speed here, the Public Order Emergency Commission was a creature of statute. It's mandated in the Emergencies Act itself that there must be this review. And at the end of that rather exhaustive set of hearings, the commissioner, Paul Rouleau, found that the government was justified, that it basically complied with the tests set out in the Emergencies Act. Now, the federal court has found the opposite is true, that it was not justified. And I'm curious, now that you've dug into the decision, where that divergence took place and where, if there was like a pivotal point, Justice Mosley disagreed with basically Commissioner Rouleau.
So he doesn't say that. I mean, it's obvious that he is disagreeing, but I think from what seems like one of the key areas of disagreement is on the threshold of threats to the security of Canada. And that is not what this case actually turned on. This case turned first on whether or not a national emergency existed, and Justice Mosley found that it did not. But the real question for lawyers who are interested in the Emergencies Act is this issue of what is a threat to the security of Canada. And in the legislation, the Emergencies Act, that is a term that the legislation says has the same definition as given to the term in the CSIS Act, another piece of legislation. And the CSIS Act requires there to be a threat or actual serious violence for a ideological or religious or political cause. And Justice Mosley disagreed with Justice Rouleau about about the flexibility of that definition. And Justice Mosley found that term, because it's defined in the statute as having the same meaning as another statute, there can be only one reasonable interpretation. It cannot have the myriad of possible interpretations that the federal government has tried to give it, which includes things like economic harm, because there were border blockades. Justice Mosley found that economic harm is not a threat to the security of Canada under the CSIS Act. And it is not a threat to the security of Canada under the Emergencies Act. And he said, perhaps it should be. I don't know. Perhaps the legislature could amend it. If they want that to be the interpretation, they should amend the legislation. But it is not the role of the court to do that, to amend the legislation. But, Justice Rouleau did accept the government's interpretation that threat to the security of Canada had a sort of different meaning under the Emergencies Act than it does under the CSIS Act. And the government has continued in the announcement of their appeal to make that case that it has this broader definition that actually includes economic harm.
One of the things that I think is probably and will remain in the history books as the most heavy-handed aspect of this is the freezing of bank accounts. I mean, after you and I spoke yesterday, I had Tom Marazzo on and also Eddie Cornell, two people whose bank accounts were frozen. Cornell was actually one of the applicants in this case. And this remains incredibly overbroad. There were, the government sort of held as its defense to this, well, we only froze this small handful of accounts, but the way the emergency orders were written, they could have frozen many, many more. I mean, anyone who had donated a dime to the truckers would have been fair game as I read this and as most people would. So I'm curious how the judge really took that, because I did see one section in particular that stood out in which Justice Mosley talked about the indiscriminate nature of it, that the government really didn't do anything to prevent spouses from being affected who had nothing to do with the convoy.
So, okay, a few things. So the bank account freezing, Justice Mosley found was a violation of the Charter's Section 8 guarantee to be free from an unreasonable search and seizure. Now, in court, the government had argued that this was not even a search, which is frankly preposterous. And Justice Mosley, in the hearing, basically told them to stop wasting their time and get to Section 1, whether or not it was a justified search, because he's like, I don't know, I forget his exact words, but in the hearing itself, he was not buying this argument that this was not a search. So we know that the examination of financial records is a search. Like, there is a lot of case law that says that financial records are part of what we call the biographical core of personal information. It can reveal all kinds of personal details about a person. So, like what your socioeconomic status is, what your lifestyle choices are. I mean, frankly, I don't want my husband looking at my credit card bills, let alone Justin Trudeau. So clearly this is a search. The orders required financial institutions to give this information to the government, to police, to CSIS, and to the RCMP. So the other thing Justice Mosley said, this is a search. The other thing he found was he had to look at whether or not the search was minimally impairing, whether it was a justified limit under Section 1 of the Charter. One of those criteria is that it be a minimal impairment of the right. And he found that the suspension of bank accounts and credit cards affected joint account holders and joint credit cards. So people who had absolutely nothing to do with the protest, if they were at home in Toronto or Alberta or British Columbia or some other part of the country, having nothing to do with the protest, they might not be able to use their credit card or get into their bank account to buy groceries or to buy medication. And that happened to one of the applicants in this case. That happened to him. These family members had absolutely nothing to do with the protests, yet their accounts were frozen. That's not minimally impairing. And Justice Mosley found that the government took absolutely, this to use his words, he said he found there appears to have been no effort to find a solution to that problem. Another thing that Justice Mosley found on the credit card and bank freezing was that there was no clear standard that applied to determine whether someone would be a designated person and have their account frozen. So the police say we only froze the accounts of people who were heavily involved in the protest, but the regulations don't actually say that. So as you pointed out, someone who had simply donated to or supported the convoy might be subject to being targeted. There was no clear standard. And Justice Mosley described the process for freezing the accounts. To quote him, he said, the police just making it up as they went along. And then he also found once your account was frozen, there was no process to question the determination of why your account was frozen or how to get it unfrozen. So a lot going on there, that clearly a breach of Section 8 of your right to be free from an unreasonable search. And Justice Mosley found that breach was not a justified limit on your charter rights.
Were there any of the emergency measures that he defended that he said, actually that wasn't unconstitutional?
So he said that there was no engagement of the Bill of Rights. There was some argument on Bill of Rights. He was not interested in the arguments on international law. He found there was no breach of Section 7, which is the right to life, liberty, and security of person, because he said, while some people were detained when they were arrested, I believe he said they were arrested under the ordinary criminal code, and their detention was brief. So,
because one aspect I was interested in was, partially for selfish reasons, was the way that journalists were excluded from even reporting on this. There were some this would be something that would probably have to come up in a separate case, but there were
excluded or pepper sprayed, Andrew.
Well, both. In my case, pepper spray, but even excluded. And you had on the ground some very inconsistent decisions, like police saying that you don't have a right to walk down a sidewalk because they've decided that this is now an area that they're clearing out. And, in my case, I had a couple of points where I was threatened with arrest, even though this is the day after the protest had been dismantled. But I'm wondering, when you look at this from your perspective, and I don't want you to give the government ideas here, but the government had committed to appealing this basically before the ink was dry and before they had a chance probably to...
I don't think they expected to lose.
Well, fair enough. But I'm curious where you think they'll try to dig in on this and where you think they'll try to base their appeal.
So they can only appeal what are referred to as mistakes of law. That you can also appeal what are called mistakes of fact, but that's a lot harder. It needs to be what's called a palpable and overriding error. And so there were a number of findings of fact in this decision that will be a difficult hurdle to overcome. So on this question of threat to the security of Canada, one of the things Justice Mosley found was that the only evidence of any threat of serious violence, which is part of the threshold, was in Coutts, in Coutts, Alberta, where a number of people were arrested and had firearms. And Justice Mosley wrote that while obviously concerning, and of course it is concerning, those individuals were arrested before, I believe, before they were arrested under the ordinary criminal code. So part of the threshold is the requirement that no other law can be used to deal with the situation. And clearly these individuals were arrested under the existing criminal code. So the fact that Justice Mosley kind of found that the evidence showed there was only one threat of serious violence and it was addressed using the criminal law I think that is a finding of fact. The government can't now bring new evidence to show, there were other hardened terror cells around Canada that were a huge threat. They're stuck with that finding, and that can't really be overcome, at least not very easily. I think on errors, what they have to focus on is what we call as lawyers errors in the law. And I don't think there are errors in law in this decision. I agree with this decision completely. But based on what Chrystia Freeland said in her press conference yesterday, it seems like the government continues to emphasize this notion of threat to the security of Canada and the standard including economic harm. So they seem set on that argument. But I will say, before they can even get to that, Justice Mosley had already found that the use of the law was unjustified because he found that there was not a national emergency. And that alone was enough to find that the the invocation was unreasonable.
Yeah, and the government's insistence that economic harm even qualifies as all of these things under the Emergencies Act, I think is very, very questionable in a lot of ways. I wanted to, just before we go here, draw attention to, if you're following along at home, everyone, para 308 and 309 of I see Christine's following along. She's I see her looking for the monitors there. Basically, what he's saying here is that there was no real distinction between people that had a truck that were blocking a border effectively or blocking Wellington Street and people that just wanted to stand on Parliament Hill with a Canadian flag and stand up for freedom, as is always legal, is a legitimate form of protest. And that was something that it came up slightly in the Public Order Emergency Commission, where Commissioner Rouleau asked at a couple of points if there was ever an alternative presented. If you can continue your protest, but here's how. And I appreciated that Justice Mosley did dig in on that, where he said, hang on, someone who wanted to stand there as an individual and not block a street was treated the same way as someone that parked a semi in front of Parliament Hill.
Yeah, so this is in the part of the decision that's dealing with charter infringement. So the way the Emergencies Act was invoked, the government created regulations, and one of them was a restriction on participating in a gathering that could reasonably lead to a breach of the peace, or materially supporting the gathering or traveling to that gathering. And insofar as the prohibition would stop you from sitting in a semi truck on Wellington blasting your horn, perhaps that might have been okay. But this prohibition was not minimally impairing, which is what is required for it to be constitutional. It captured too many people. So yes, it captured the person who had been spent 3 weeks on Wellington Street, which is not, you can't blockade infrastructure indefinitely. That we are a rule of law country. You cannot do that. That is not protected expression. But it captured that person, but it also captured a person who had a poster that they wanted to walk with to Capitol Hill or Parliament Hill and stand on the grass, which is completely protected expression. So it captured too many people. It was not minimally impairing, which is one of the requirements of a law if it's going to infringe on a right, which this did.
Well, I'll give you again the congratulations, well earned, that I gave you yesterday on the show. And now the judge himself has also lauded you for your work, which I hadn't seen yesterday. So well done all around on this, Christine. I look forward to having you back on as this case proceeds. I mean, the best case scenario at this point would be for the Court of Appeal or the Federal Court of Appeal to say there's no appeal here, right?
I'm not sure if they get leave to appeal as of right or not, but I think certainly if leave is the permission of the court to appeal, I think that they would get it. I think an interesting question is if whatever the outcome is at the Court of Appeal, I mean, the timeline that we're looking at is probably 6 months from now, an appeal could be heard, and then 6 months from now, we might get a decision. But
so a year until there's a Federal Court of Appeal decision, you're thinking?
I think at a minimum. And then when we talk about if there's any possible delays, how close are we pushing it to an election? Because I do think if there's a change of government, the desire to appeal this decision will perhaps be lacking.
Yeah, fair enough. But assuming just that it goes through the normal channels here, you've got a hearing under the Federal Court of Appeal decision, and then potentially beyond that, Supreme Court of Canada. How long would that add to the timeline?
Another 6 months for the appeal and then 6 months for the decision.
So, and you're right. So we're well into, a year into the next government's term, possibly, whether there's a change or not. So ideally here, there would be a bit of contrition from the federal government. But right now, we're not seeing that.
I think they'll probably rush it because I think they can read polls as well.
Yeah, fair enough. All right, well, we'll get the political analysis next time. Christine Van Geyn, Litigation Director for the Canadian Constitution Foundation. Well done on this, and thanks so much for coming on again.
Thank you.
All right, if I keep having her on, eventually she's just going to take over the show because she has such an incredible way of distilling down these things into understandable terms. But I wanted to switch to the political side of this for a moment here because one of the things that's easy to forget for a lot of people is how much of a tectonic shift in politics there was at the time of the Freedom Convoy. And we had Erin O'Toole, who was the leader of the leader is questionable, but who nominally led the Conservative Party of Canada at the time, who was very weak on the Freedom Convoy, would not say whether he was going to meet with the truckers, wouldn't say if he was supporting it, would say that we need to get more truckers vaccinated and that's how we're going to solve the trucker vaccine mandate. And his lack of support for the Freedom Convoy was a big reason that Erin O'Toole was ousted. And the rapid pace at which things then evolved with his replacement with Candice Bergen, who was the interim leader, had been O'Toole's deputy leader, but broke ranks with him to support the Freedom Convoy in a statement that was published. I can't remember the exact night. I believe it was on the eve of the convoy's arrival in Ottawa, if memory serves. And then Pierre Poilievre, who famously turned around on the steps on the way into that one fateful caucus meeting and said that, in his own way, that he was supportive of the convoy and wasn't going to let the media malign those who were individual bad actors because he said in aggregate, this is a peaceful protest. Well, Candice Bergen, who is now retired from politics, had a line on X, formerly Twitter, that was actually somewhat moving. She says, "I recall vividly and with pride when our Conservative caucus made the collective decision to oppose the Emergencies Act being used against peace-loving Canadians protesting Liberal overreach. We decided in that moment that we wanted to be on the right side of history, and that we are." Candice Bergen, I have plucked her out of political retirement for the next 10 minutes or so. She joins me on the line now. Candice, wonderful to talk to you. Thanks so much for coming on today.
Great to see you again. Thanks for asking me.
You had, I'll say it was actually quite a moving post you made to social media yesterday, where you talked about how proud you were when the Conservative caucus banded together and decided to oppose the Emergencies Act. And I've made the point in the past that this is not, you could oppose the convoy and also oppose the Emergencies Act, although I know many of the people in your party and yourself were supportive of this protest and large parts of it. But why were you and your caucus so firmly against the Emergencies Act when this first came up?
Well, Andrew, you have to remember the context of the moments that we were in. And you're right. Many of us supported the reasons that the convoy were there, that the people were there. Many of those people were our constituents, but we also knew that they needed to head off the streets. They needed to go home. That was our wish. But we wanted the Prime Minister to listen to them. That did not seem to be happening. So when the Emergencies Act was invoked, we had to make a decision, and there was a lot of pressure. You'll remember the media, the mainstream media, not all media, but most of the media was saying this was the right thing to do, and we had to support it. And so we came together as a caucus, which is what I find these MPs that I've been so privileged to have worked with, we do so well. We came together, we had a really good conversation in our caucus, heard all sides, and we heard, should we support it? Should we be fully against it? Should we ask for an amendment? And, without breaking any kind of cabinet or caucus confidentiality, I can just tell you what an incredible conversation and discussion we had as a caucus back in February 2022, talking about freedom, talking about our constituents and what we needed to do as parliamentarians. And we talked about history and where we wanted to be when all of this was said and done in 5 years, 10 years, 50 years. And we decided overwhelmingly, and we were very proud and very strongly supporting, working and fighting and speaking against the Emergencies Act.
That history aspect is incredibly important. I made the point a while back on my show that, at one point, William Lyon Mackenzie was a traitor who was in exile, and then you fast forward a decade and he's a member of parliament. I mean, things can change, and with the benefit of hindsight, even the judge said this in the ruling yesterday, you can get a more full picture of things. And that seems to be happening here as well. We're in the moment. You had a lot of anger, of course, in many directions, but the further away we get from this, that there's this surreal aspect when you think, wait, did the government actually freeze people's bank accounts?
Yeah.
And that was the Emergencies Act. That's what they did here. So when you talk about being on the right side of history, I know it's thankless being in politics, and you had to bear a lot of the criticism from the media and the left for this, but I do think you're going to get that in the end.
Well, and that's gratifying, absolutely. But what I'm thinking about today, and my heart just goes out to the people who are still suffering because they were part of that convoy. They supported the convoy. The fact is that the government's position on the protesters, most of the media's false betrayal of or portrayal of what happened in Ottawa have really set a lot of Canadians who were not in Ottawa against the protesters. And, I know even when I would go home and talk to people and I would say, listen, yes, they need to leave the streets of Ottawa, but these people are happy. They are peaceful. You look at the protests that are going on right now supporting Hamas and how different those protests are being portrayed. And yet people throughout the country were being told that these were violent, hateful protests and that the Emergencies Act had to be invoked because they were so dangerous. These are the people, my heart goes out to the people who have been lied to by their own government and the media, and then the people who are so falsely maligned. So, I'm really, really proud and glad our caucus took the stand that we did. But, we need to learn from this, Andrew. And if we don't learn from this, I'm afraid that the whole agenda of wedge, stigmatize, and divide Canadians will be won by Trudeau. If we don't learn from this, which thankfully I believe that we are, I see what our leader Pierre Poilievre is doing and caucus is doing, but I do worry about our country as far as the media. I honestly, Andrew, I'm glad that you've had me on. I would love to ask some members of the media. I was grilled by Evan Solomon. I was absolutely grilled. How dare you not support the Emergencies Act? And how dare you support these people? What does he have to say for himself now? How about some of the writers in the Globe and Mail, for example? Where's their accountability? And I feel that unless there is some real reckoning, government will be held to account, Andrew. This government will be held in terms of the vote. They will be held to account at some point. But there are many people, elites, academics, the Ottawa bubble. We know the Ottawa bubble. So I'm really happy, proud that we were on the right side. I'm so proud of the caucus that I served with, incredible members of parliament, but we better learn from this.
You are right. The media malfeasance throughout the entire protest, and I'd say the entire COVID era was quite something. There was one Globe and Mail reporter that posted online that there was a wrecking ball outside Trudeau's office, but it was actually the weight holding the Canadian flag there that was, like the size of, my fist or something. And then you also had CBC musing that this was all some foreign Russian financed operation. And there hasn't really been ever a reckoning, let alone an apology from these people. And I think a lot of folks have really expected this could all just be kept in the past.
Well, and I guess in a sense, their reckoning has come in that most of the media in Canada has lost all credibility, especially with, I would say, 40 and under. They have no credibility. And so 40 and under are using their dollars to show where they want to get their news from. And it's not the CBCs. It's frankly not the CTVs, probably not none of the mainstream. So I guess there is that reckoning. But, I do remain hopeful, Andrew, as much as I'm frustrated as I look back. And I think that there still is a false malignment of actually peace-loving Canadians who came to Ottawa asking for their prime minister to say, I hear you. And yes, we are not going to continue with these mandates. There will be an end. And this was all we were asking from him. And I know this is what these Canadians were asking for. They were falsely maligned. So although I feel a real sense of injustice was done for them, I am hopeful for our country. When you speak to people one-on-one, people are good. People in Canada, I believe, are genuinely good people. And what they're looking for is leadership. And that's what I think we're all hoping is going to happen after the next election. We're going to have leadership that will make decisions in the best interest of the entire country, not just to wedge, stigmatize, and divide for his own or their own political gain.
Were you surprised that the NDP went the way they did on this? The party of Tommy Douglas, the party that has put itself in protests more times than anyone could count. Were you surprised that they ended up? Jagmeet Singh has tried to do a bit of revisionism here and said it was only reluctantly, but they were quite supportive of this at the time. And I'm curious if that, when you were in the thick of it there as leader of the opposition, if that shocked you in any way.
Well, we'd seen Jagmeet and the NDP just placate the Liberals and basically follow along for so long. You know, Andrew, the irony is the Liberal Party has strayed so far from what it was. It is not the party of Jean Chrétien, of even Paul Martin, John Manley. It is not the party that most traditional Liberals knew. And I would say the NDP have very much strayed from what they were as well. They are not the party of Tommy Douglas. And, maybe that's a good thing. Maybe times are changing and we're all changing and adjusting. But the center seems to have moved. And the people who thought we were in the center now see that many who were left Liberals, but more in the center, have moved far, far to the left. And then the NDP are... we don't even know where they are, actually. They're left, but they're not left in terms of supporting workers or protesters, unless the protesters are protesters that they support. They haven't. And I mean, that's the other thing we haven't even really talked about. When you compare the protesters that were in Ottawa in early 2022 versus the anti-Semitic protests and the hateful protests we have seen going on across the country in support of the terrorist Hamas organization. You look at the comparative of the two and the media coverage and the government response to the two different types of protest. So what does that tell you?
Yeah, no, that's very well said. And this court ruling is, I think, vindication for a lot of people, yourself included, but it's not the end of the story, certainly, when you talk about the media and the fact that the government has still been unrepentant about this. So we'll hopefully see a similar reaction to the Court of Appeal and all the way to the Supreme Court. But I realize I've plucked you back into the political world here, and I'm so grateful you did it. Candice Bergen, we always get people saying how much they miss you in politics, but I hope you're doing well, and I thank you so much for joining me today.
Thanks so much, Andrew. Great to be on. Happy to do it anytime.
That was Candice Bergen, the former leader of the Conservative Party of Canada. Now, one thing I want to make a point of here, and I asked Candice near the end about Jagmeet Singh's role in all of this. The NDP has been incredibly weak. No, that was the sentence. They've just been incredibly weak. But on this in particular, and that revisionism from Jagmeet Singh is kind of fascinating. Here's him saying yesterday that it was only reluctantly that he backed the use of the Emergencies Act.
From the beginning, we said and we maintain that the reason we were in that crisis was a direct failure of Justin Trudeau's leadership and also other levels of government that failed to act, to take the challenge presented seriously. Their inaction resulted in a serious crisis where we reluctantly supported the invocation of the emergencies measures. We said that was something that we reluctantly supported. And then we also were very open to the Rouleau Commission and the work and the accountability measures to assess whether it was the right decision and what needs to be done differently in the future. The ruling has been passed down. I understand there will be an appeal of that ruling, and we will follow closely to see the outcome of that appeal.
Reluctantly. Okay, here's Jagmeet Singh 2 years ago when he was announcing his support for the use of the Emergencies Act.
With the War Measures Act, then NDP leader Tommy Douglas said it was like using a sledgehammer to crack a peanut. Now, of course, today in Ottawa, we have seen a bunch of aggressions of all sorts, but no one has been kidnapped. No one has died up to now. So I guess my question is, how will history, remember you as NDP leader with this Emergencies Act and all the entrenches to civil liberties right now?
I think it's really important to reflect on the War Measures Act for just a moment. The War Measures Act was a sledgehammer. And that's why there were serious problems with its application, because it was a very broad and overly powerful piece of legislation. That's why it was repealed and a new legislation was brought forward. The Emergencies Act is nothing like the sledgehammer of the War Measures Act. It's not at all the same. It doesn't even include the powers for the military. It doesn't include military at all. It's a very different piece of legislation, and it is much more targeted and specific. And so it's a very different time.
Oh, it's different. It's no big deal. It's not like it's the War Measures Act. I'm not hearing that reluctance that Mr. Singh speaks so fondly of yesterday about the Emergencies Act. And let's go back to 2021. Now, this is a visual a visual display here. I have written to Justin Trudeau asking him to consider using the Federal Emergencies Act to help Ontario. This could help make sure vaccines are getting to people who need them and help sick workers get paid when they stay home. We must do everything possible to keep people safe. And then there is a letter there. I'm not going to read the letter because I understand some people listen to the show when they're driving, and I don't want you to veer into the ditch because you've fallen asleep by me reading the dulcet tones of Jagmeet Singh to you. But here we have him saying it's a national emergency that warrants the Emergencies Act because the federal government isn't getting enough vaccines to Ontario. And he wants us to believe that it was only reluctantly that the NDP backed the use of the Emergencies Act 2 years ago. So Jagmeet Singh has once again shown that he has no spine. As I joked when I saw him riding his bike, it was a feat of physical brilliance that I still don't quite understand. How the kinetic movements were even possible without so much as a backbone to allow him to steer that bicycle down Wellington Street. But Singh says, "Oh no, I didn't realize. I only kind of, sort of, ish sort of went along with it, but the record shows something else there." I played a Chrystia Freeland clip yesterday. I had 2 more of them today, but again, I'll spare the audience and won't do it here. But I did mention at the beginning of this program something that made me chuckle. This was a graphic that apparently was made by one of the members of our team here. This is now that's actually a hate symbol. Yeah, the show is going to get canceled by the CRTC podcast registry before long. That is like a new Canadian flag. If you're listening to the podcast, it's got a bouncy castle in place of the maple leaf. So the Canadian flag was already enough of a hate symbol. This one is even more so. So be careful where you fly that thing. You never know what might happen to you. But what's fascinating here is that we have a government that has been so utterly unrepentant about this. A finding from the federal court that the constitutional rights of Canadians were not respected. Now, it's interesting to square that with a comment Justin Trudeau made on Valentine's Day 2022. Take a look.
We're not using the Emergencies Act to call in the military. We're not suspending fundamental rights or overriding the Charter of Rights and Freedoms. We are not limiting people's freedom of speech. We are not limiting freedom of peaceful assembly. We are not preventing people from exercising their right to protest legally.
Ooh, okay. We're not ignoring your charter right. Is that, do I have that right? I'm just looking at that he said that. Okay. So here we have a leader doing what I had at the time remarked as being a little bit odd. And I said, if a government has to like pinky swear and promise to you that it's not trampling on your constitutional rights, there's a good chance it is trampling all over your constitutional rights. And now a judge has at long last agreed. So we're going to continue to follow this along. As Christine Van Geyn said, it's likely to be 6 months until there's even a hearing on this, and then another 6 months to get a decision. And then you may have beyond that a Supreme Court. Here's a question that I want to put to Conservative leader Pierre Poilievre next time I speak to him. If you form government and this appeal is underway, will you commit to dropping the appeal? That's a question that I have for the Conservative leader, and I would love to hear an answer. So if you run into him at one of those photo lines he does, please ask and report back if you get an answer. I'll send an email off to his office once I get off air as well. I just thought of that question, but it seems like a good one. I wanted to shift from one trampling of your rights to another here. We have on an ongoing basis here the federal government going after the rights of law-abiding gun owners in this country. We have a so-called buyback plan in which the government is going to buy things back that it never once owed in the first place. They're still trying to find a vendor to manage this buyback program. This was announced, just to put this into perspective here, just shy of 4 years ago. And still, there is no program in existence yet. And the fact that they haven't found a vendor yet, normally I would accuse governments of dragging their heels and slowing things down. In this case, I'm going to say go as slow as you want to, guys. I am in no rush to have my property confiscated. Rod Giltaca is the executive director of the Canadian Coalition for Firearm Rights. It's always good to talk to him, and he joins us now. Rod, welcome back, sir. Your video looks better than mine. You've got that good podcast set up there. Welcome.
Well, thank you for having me, Andrew.
So again, I mean, normally I never want government to be mired in bureaucracy. In this case, I'll kind of make an exception for it here. But legitimately, what is the holdup here? Because originally this was supposed to not just be in motion, but done by 2022. By May of 2022, there was supposed to be every one of these guns picked back up by the government. We're now 2 years beyond that, and not a single gun has been confiscated.
Well, the holdup is that the challenge to doing a national buyback in a country like Canada, unlike, let's say, New Zealand, Canada is 10 million square kilometers. So there's a lot of challenges there. The government has tried a lot of different things, ended up being headed off at the pass, a lot of dead ends, right? They wanted Canada Post to do it. Well, first they wanted the RCMP to do it, and they're like, no, thanks. We have to this other thing that we're doing called policing. Then they wanted Canada Post to do it, and they're like, you want people in Canada Post outlets to be sitting on hundreds of apparently assault style firearms, and our employees are the only thing between these firearms and the criminal element. And now they're asking gun stores to do it, which gets really, really tricky.
Yeah, and I mean, you obviously have, I mean, gun stores, as you and I have spoken about it, as I've spoken about on the show, have been among those most directly harmed by this, because they've been saddled with inventory that they've been able to do nothing with, very little communication from the government, very little confiscation, or well, consultation. There's a Freudian slip. But the one point that I would stress there is that they're also generally opposed to this. So they don't want to be agents of this confiscation regime.
Well, it puts them in a really, really terrible position if you think, they can't sell handguns anymore. Handguns and handgun ammunition was big business for a lot of gun stores. They can't sell a wide variety of semi-autos that they used to. So their inventory, their possible inventory, or the products that they can carry has been dramatically reduced. And then the government says, hey, here's a revenue stream for you in helping people comply with the law. So I think that on one hand, you have a lot of gun store owners going, I could really use the business. On the other hand, it's like, well, do I want to destroy my business by giving in and being an agent of confiscation on behalf of the Liberals against the people who I want to be my customers? I'm glad I'm not in that position, but I would not be surprised if the overwhelming majority of gun store owners decide they want nothing to do with this.
Yeah, and I think one thing that was really, really encouraging to see is Alberta and Saskatchewan take the stand they did and say, you know what, you may control the criminal law, but we control how police resources in our province are deployed, and we are not going to allow police to engage in this function. I was hoping, it would just magically cause this national ripple effect and every province was going to do it. That hasn't happened, though. So right now, if the Liberals had their way, we would still, in the majority of the country, see this brought to fruition whenever this program comes, with legal appeals notwithstanding.
Well, yeah. If the Liberals had their way, but I think they're handling it like they handle most things, right? They'll come out with a big press release, full court press. This is what we're doing, and this is exactly what we said we were going to do, and that's exactly what we're doing, and we're keeping Canadians safe and doing all this garbage that they've done for 8.5 years. And then when reality shows up, they completely fold like a cheap suit. Like that is exactly what the Liberals have done, I guess, other than pot. But if you think of it, only the Liberal government, the Liberal Party of Canada, can lose money selling weed. But it's all been about press releases and, I don't know, gaslighting, I guess you could say. But this time it's different, because this time the challenge is so great that it would take a highly competent group of people to make this happen. And lucky, I guess, for gun owners for now, that doesn't exist in the Liberal government. So I guess we're going to have to see where it goes from here.
I just wanted to get you to give an update, if you could, on where the legal side of this is, because I know there were a couple of challenges going on. I know you've had some unsuccessful rulings, but is there still a glimmer of hope on that path? Well,
we are appealing. And I can't claim to say I'm not envious of what happened yesterday. But I think if anything, what an interesting time in Canadian history to even just be monitoring the judiciary, right? On one hand, the government comes in because of an unrelated event, which was the impetus for the assault style weapons ban, which was Nova Scotia, where this perpetrator had smuggled all of his firearms that were used in those shootings from the United States illegally. And then Trudeau's like, we need to ban guns in Canada. And then you have a court saying, well, you have no property rights. You have no rights of self-defense. That's another charter question that we asked. And we had a question that was very clear, and we still believe we clearly should have won on that, which is the government, it was the OIC, the Order in Council was ultra vires. It's very similar to the ruling that came out yesterday. The government didn't have that authority. So they slap us all down on all counts with a very scant decision. And then a month later, a federal court decides that it is unreasonable and unconstitutional for the government to ban plastic shopping bags and plastic straws. I mean, that was a line too far. And then we have this ruling, yesterday, right? So it's the judiciary is all over the place. The moral compass in this country in so many corners is spinning. Can't find, north anywhere, apparently. So I hope that we'll be successful on appeal because, again, property rights, self-defense issues, and the role of government in our society, all at stake in that case.
Well, and the one point that I think has always remained important here is that a political solution is always available. It's always possible for the government to one day snap its fingers and say, we're no longer proceeding with this. Now, that's unlikely under this government, but if this process is delayed and delayed and delayed until past the next election, another government, I mean, let's be real, the Conservatives are the ones most likely at this point to form government, could still say this is not happening and put it dead in its tracks, could it not?
Well, it's going to take legislation on some. It's really complicated how the Liberals have done their OIC and Bill C-21 and C-71 before that. The Order in Council, that could be struck down, but it gets quite complicated. So it may require legislation, which will require a Conservative majority government. But yeah, in Canada, as I've said ad nauseum, in Canada, using the British parliamentary system, our government can do pretty much whatever it wants to anybody it wants. The courts are, I'm not going to say, powerless, but they have a lot less power than they have, say, in the United States. And then, of course, they're influenced. I think we can all agree on that at some level. But the whole system gets pretty complex. But what one government does, another government can undo is really the rule of thumb in our system, even though those powers are pretty dramatic. But that's a political solution is the easiest path, I guess you could say, to Canadian gun owners just being left alone and getting their property back.
Rod Giltaca, head of the Canadian Coalition for Firearm Rights. Always a pleasure, sir. Thanks for coming on today.
Thanks, Andrew.
All right, that does it for us for today. We will be back tomorrow to close out the week here on Canada's most irreverent talk show. Thank you, God bless, and good day to you all.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.